Transfer of interest of a member in the company not having a share capital. Section 56 of Companies Act 2013. So now generally many professionals associate with transfer procedures only with the shares. However, companies limited by guarantee and certain other companies may not have share capital, but the member can still transfer their membership interest subject to certain legal provisions. We'll discuss what exactly how it will transfer, what is meant by a company not having a share capital, applicability of section 56 of the Companies Act 2013, and requirement of transfer deed, use of form SH4, and relevant rules and legal interpretation, practical compliance procedure. So we can begin with the meaning of the company not having a share capital. A company not having a share capital generally refers to a company limited by guarantee. So in such companies, members do not hold shares. Ownership is not represented through their share certificates. So members contribute a guaranteed amount in the event of a winding up. So membership right exists without shareholding. So examples, Section 8 companies limited by guarantee. There are professional associations, and you can see clubs, chamber of commerce, certain non-profit entities. Even though there is no share capital, member possess interest in the company, and such interest may be transferable subject to AOA, Articles of Association of Company. Section 56 of the Companies Act 2013, which deals with the transfer and the transmission of securities. This section also specifically covers transfer of interest of member in the companies not having a share capital. It provides the proper instrument of transfer must be executed by on behalf of the transferor and transferee, and delivered to the company within the prescribed timeline. So even in the absence of shares, a written transfer instrument is a mandatory. So requirement of proper instrument transfer, the law requires execution of transfer instrument and signature by transferor or transferee and delivery to the company. So this covers authenticity of the transfer, proper record maintenance, prevention of disputes, because this is a written agreement, written execution of SH4, compliance with statutory requirements. Without a valid transfer instrument, the company should not register the transfer of membership interest. Rule 11 of Company Share Capital and Debenture Rule 2014. It prescribes SH4 as the format for transfer of securities held in a physical form. But an important clarification is provided under Rule 11, Subrule 2. Form SH4 shall also be used for transfer of interest of a member in the company not having a share capital. So further reference to securities in the form shall be read as reference to interest of the member. So this is a very important clarification, because many professionals wrongly assume that SH4 is applicable only to the shares. So the practical procedure for transfer of membership interest. So let us understand. First, verify AOA, Articles of Association. Before transfer, check AOA. Verify restrictions or approval requirements. Examine admission conditions for new members. In guarantee companies, RTLs play a crucial role. Then execute Form SH4. The transferor and transferee must execute SH4. Details generally include the name of the transferor, name of the transferee, and description of the membership interest, consideration amount if any, date of execution, witness details. So appropriate stamp duty may also apply depending upon the state laws and nature of the transaction. And then submit to the company. SH4 must be delivered to the company along with the supporting documents. Then board approval. Board of Directors generally considers eligibility of the transferee and the company's articles, as per the articles, compliance and validity of transfer documents. Therefore, the board may approve the transfer through a board resolution. Then updation of records. Upon approval, register of members must be updated. Old members' name removed and new members' name will be entered. Thank you.